Hello and welcome to our podcast. My name is Kelly Murphy and I'll be your host today. Every year on April 26th, people around the world celebrate World Intellectual Property Day, a time to recognize the importance of creativity and innovation. This year's theme, chosen by the World Intellectual Property Organization, is Intellectual Property and Music at the Rhythm of IP. So today on the podcast, we're diving into one of the most important topics in the music world, copyright. We're pleased to welcome Daniela Basson, partner and trademark agent at Stewart McKelvey, to help us unpack the challenges of copyright infringement in the music world. Daniela, thank you for being with us today.
Thank you so much for the invitation.
So first, can you tell us about who you are and what you do as an IP lawyer?
Sure. I'm a litigator based in Halifax, in Nova Scotia. I have practiced in the area of IP for over 20 years. There are three main things that I do as an IP lawyer. So first, I am involved in a wide variety of IP disputes, including copyright, trademark, and patent disputes. Some of these are local, some of these are international. Some involve very advanced technology, and others would be low tech. Each case, I would say, is unique. Second, I work on the avoidance of IP disputes. To do this, I get involved before IP problems really present themselves. So this means educating IP owners as well as users early in the process to better understand and have more awareness of which activities carry more or less risk from an IP perspective. I also work on IP strategy, especially for business owners who may be new to the world of IP. I like to work with companies who are innovating in their field and want to leverage those innovations by protecting the surrounding rights.
Since we're focusing on music and intellectual property, I understand you've identified disputes involving famous musicians for our discussion today. Can you walk us through a few of these disputes, the kinds of conflicts they highlight?
Yes, I'm going to talk about three cases, which I think are quite interesting and revolve around a common question in the field of pop music. So the question would be, when does copyright infringement occur? So I would like to talk about a Canadian musician, an American musician, and an English musician. And I should note that the opinions that I'm expressing today are my own personal ones and not of some organization that I might be affiliated with.
I'm curious to know which dispute involving a Canadian musician did you choose to share with us?
So I'm talking about Sarah McLachlan. 25 years ago, the Supreme Court of British Columbia decided a claim brought by Daryl Newdorf, a former collaborator and drummer of Sarah McLachlan's. He wanted to be recognized as a co-author of 4 songs that were on her debut album called Touch. He was looking for damages for copyright infringement. He asserted that he had made significant contributions to these 4 songs, but he was not credited for them.
And what was the outcome of the decision?
Well, the court dismissed the claim and concluded that Daryl Newdorf could not meet the legal criteria for being recognized as a co-author of the 4 songs in question.
And can you tell us why you decided to share this story with us?
So, even though this decision is not recent, it is very interesting because it examines in a lot of detail the circumstances in which the contributions of a collaborator, so a musical or artistic collaborator, could be recognized as those of a co author or a co owner of copyright.
Interesting, thank you. And if there's a takeaway from this, what would you think that message would be?
So there is a somewhat controversial point in the decision. The court concluded that the collaborator here could not prove a mutual intent to co-write the songs in question. So this element of mutual intent has actually been rejected by some courts. But at the same time, some courts have, or some decisions have implicitly or explicitly accepted this element. So you could say that the debate over Sarah McLachlan's copyright continues to some extent.
Earlier in our conversation, you mentioned the second dispute you were going to share was about a famous American musician and copyright infringement. I'm eager to hear about this. Can you please elaborate?
Sure, I'm talking about Taylor Swift, actually. So a copyright infringement lawsuit was filed against Taylor Swift for her song Shake It Off. The songwriters, Sean Hall and Nathan Butler, claimed that Taylor Swift copied the lyrics from their 2001 song called Players Gonna Play, which was recorded by a band called 3LW. So the songwriters claimed in particular that the phrases players gonna play and haters gonna hate from Shake It Off infringed on their copyright.
And what was the result of the case?
So Taylor Swift's legal team did try to dismiss the case very early and summarily, but this legal move actually was not successful. So the case did get ordered to go to trial. But in the end, the matter was resolved and the parties actually abandoned the case in 2022. So this actually was just in time for Taylor Swift to re-record her album 1989, which of course includes the song Shake It Off.
Fabulous. Thank you. And so, in your opinion, what's an interesting feature of this case for our Canadian audience?
So I would say that the decision of the US District Court here is very interesting for its reliance on expert evidence. Both the claimants and Taylor Swift had relied on experts in this case. They analyzed the lyrics in the songs in great detail. So they looked at the grammar, the syntax, the meaning, the structure of the words. The judge in the case actually referred to the battle of the experts. And this kind of evidence from a musicologist or a literary expert could be relevant even in a Canadian case. And I would say it also shows the complexities with which a copyright case comes and how complex it can be to actually prove a copyright claim. So speaking of musicologists, I did want to just add their work can be quite varied. So they can look at things like the history of music, the development of musical genre. Also, they analyze musical compositions in terms of harmonic rhythms, melodies, those kinds of things as well.
Interesting. So I guess this shows that how much the roles of experts can influence a decision in complex copyright cases. It's really interesting. Okay, so next is the English musician that you mentioned earlier. So I'm kind of curious to know what case are we talking about here?
So I'm talking about Ed Sheeran, actually. So another copyright infringement lawsuit was filed against Ed Sheeran for his song called Thinking Out Loud. This song was alleged to have copied musical elements from the Marvin Gaye song Let's Get It On from 1973. So the plaintiff there was actually a company that held the rights to the Marvin Gaye song. And the company claimed that Sheeran had copied the rhythm and the chord progression from the sheet music of the Marvin Gaye song. And I would just note that Thinking Out Loud actually had won the Grammy for Song of the Year in 2015.
And what was the result of the case?
So Ed Sheeran did win this case. He was able to show that the chord progression and the harmonic rhythm in his song were actually quite common in popular music and not unique to the Marvin Gaye song. So this meant that there was no copyright violation for the use of these common musical elements.
And again, here for our audience, what's the key takeaway from this decision?
So I would say that Ed Sheeran is not just a good songwriter, he's also a very good witness. He performed before the court with his guitar, and he did this to be able to show how common the particular elements are in pop music and not just in these two songs. And he even performed a mashup of the two songs as part of his testimony.
Brilliant.
So, and another point just to underline from this case is the numerosity requirement from US law. Ultimately, the number of basic musical building blocks in common between the two songs was simply not sufficient to establish copyright infringement.
Fantastic. So finally, to end with the following question, for all artists out there, what is one best practice that you'd like to share from your experience?
So on that one, I would quote from Taylor Swift's lyrics, "If you fail to plan, you plan to fail." The most important piece of advice I could give is to think about protecting your IP rights as early as possible and to try to protect them sooner rather than later. It could be a simple contract, a simple negotiation, even a simple registration. But I can guarantee you, whatever effort you put in at the beginning of the process, you will save a lot of effort at the end.
Excellent advice. Thank you so much, Daniela, for joining us today and sharing your valuable expertise. In the wake of World Intellectual Property Day, we've had the opportunity to reflect on the importance of protecting artistic and musical creations. Your insights have been incredibly helpful in shedding light on these important issues. This conversation reinforces how vital intellectual property is in supporting innovation and creativity, not just in the music industry, but across many fields. Thanks again for tuning in. Until next time.